Hey everyone, welcome to Taking the Pulse, a healthcare and life sciences video podcast. I am Heather Hoops Matthews here in the studio today with Maynard Nexsen, healthcare and life sciences attorney Matthew Roberts. Matthew, good to be with you.
Good to see you.
And we are joined today by one of our colleagues. Bryan Baysinger is a seasoned intellectual property, cyber, and privacy attorney. He is joining us today to discuss both intellectual property and AI, artificial intelligence issues in the life sciences industry. Bryan, thank you for joining us.
Thanks for having me. I appreciate it.
And I guess we should start by saying congratulations.
Absolutely.
As well, because we understand you are the new intellectual property practice group leader for Maynard Nexsen, which is a national law firm. So start us off by telling us a little bit about your group and your goals for the group.
Yeah, no, thank you, Heather. I appreciate that. Matthew, good to see you. Yeah, it's quite an honor, and we've got a really talented group of folks on the team. And so, I really see this position as a facilitator, as really kind of a connector for the group. So one of my big goals is try to get everyone, rowing in the same direction and working together, but also, to triage work to the best attorney for the job. And that's been something that's, it's a little bit mystical around IP because it's so hyper specialized. Folks often, don't know the resource that they need to go to. And I see myself as really in this practice group leader role, translating and really kind of, communicating to not only internal, but to our clients and to folks we have and we're servicing, what our various skill sets are and what we can do and what we can bring to the table. So I'm excited. We've got a really, really strong position. We've got great growth trajectory, and we're going to continue to grow.
So Bryan, you have a lot of experience in the life sciences area. You do a lot of work for life sciences companies. Can you talk a little bit about the primary intellectual property issues that life sciences companies face and are dealing with?
Yeah, that's a great question, and I think I want to go back to basics here. I think one of the biggest issues life sciences companies face is actually understanding and identifying the IP they have. Right? I mean, it's one thing to say, yeah, we've got IP, but to be able to actually point out the assets, capture the assets, identify what's there. That's a big part of what we do. We always tell clients, don't pick up the phone when you think you have IP. Pick up the phone and we'll start helping you evaluate your IP. It's one of those things where, it's hard to recognize at times, and you may be sitting on some very important assets and not realize it. And there is risks with IP because there is time bars to things. So, one of the things we like to do is get with the clients early, get with the R&D team, and start mining. We're consultants as much as we are lawyers. So I try to communicate that, think of us as a consultant in the aspect of helping you develop your IP strategy. And then the lawyering part comes naturally. The second thing I see with life sciences companies is the ability to leverage IP. And what I mean by that is, there's many reasons life science companies acquire IP. And a lot of times they acquire these assets without any real sense or purpose or direction. And so, one of the things we try to communicate is how to leverage it, right? Don't put your Rembrandt in the attic and let it collect dust. Figure out how to leverage that. And whether it's fundraising or whether it's asserting, rights to keep competitors out of the market, I think that's another thing that, oftentimes we see them, rack up IP like trophies and put them on a closet, but they don't really, market that and sell that ability. And so communicating that message is another aspect that we try to help life sciences companies with. Lastly, I think, one of the other issues is technology waits for no one. And, that's one of the situations that we communicate with clients. And obviously, budget's always a concern and what they're trying to do is a concern. But what I mean by technology waits for no one is you don't really know what your competitors are doing. They're out there innovating. The thing about capturing IP is we're a first to file system, at least on patents. It's a rush to the market. Trademarks, it's a first to use. So it's a rush to use it. So a lot of IP is really based upon how quickly you can act. And, I've got a great client that he's got a poster behind his office desk that says, innovate or die. And, I thought about that and I said, well, that's probably a take on it. But, he said, I have to live that mantra and I want my employees to live that mantra because we're in a fast paced area with lots of competition and we survive by innovating. And, I think that's one thing to kind of to talk to engineering teams and to talk to these life sciences companies about is you can't rest on the product you've done for the last 10 years. That will eventually be eclipsed by something else. And so you have to be active. You have to innovate, and you have to continue to innovate.
Well, we've all been inundated with AI issues in the legal profession and in the life sciences industry, and we are hearing a lot about AI-generated content, materials, and research, and it's creating some concerns, questions within the IP field. But how is this new day of AI and how it's being used and its increasing use impacting the life sciences industry?
Yeah, that's a really great question. Highly relevant. There isn't a day that goes by we don't get something similar. So, the way I see it right now, the biggest impact, at least for life science companies in AI, is really around what we copyright law. We'll hear articles being published, marketing campaigns being developed, all through generative AI. One of the cases we're tracking right now is the New York Times versus OpenAI case. And that's the real first foray. This is the case where the New York Times was able to prompt engineer OpenAI and Microsoft and to basically generate articles that were close or close enough to actual New York Times articles. It's a very, very hotly contested area. This is the one that is, I think, going to make the most waves as far as direction and where we can go utilizing generative AI. Previous cases, such as the Thomson Reuters case, which was against Ross Legal, that was more of a traditional AI. That was more of your rule-based natural language processing, tokenization. This generative AI brings about quite a bit of questions and debate as to who's in the right, the content creators, in which the information was originally obtained, or to escape that, or are we willing to give them fair use? Fair use is an exception to copyright, and in the fair use world, it's really an admission that we have the copyright material, but society deems that for public reasons or certain reasons we're allowed to use those works. I'm not sure where the courts are going to land on this, but I think generative AI is an incredible tool, and I also respect the artists and authors that the material was built from. And so we'll have to see how this plays out and how fair use is interpreted. But it is something to continue to monitor and something we will keep our clients well apprised of.
So how are you advising your life sciences clients on the use of AI as they develop and protect their IP? Are there certain pitfalls they need to be aware of? I mean, you mentioned that you need to be aware of the copyright issues, but it seems like it's another set of things they have to worry about as they go along the research process.
That's right. Yeah. And so we really only hit on copyright, and patents is another area which generative AI is being utilized. With patents, the patent office has been very receptive to the use of generative AI. Now, AI cannot be an inventor, but if you're an inventor and you conceive of an invention, you can use AI, generative AI, to help refine refine your idea, to work with the constructs of your idea and to prove your idea. So reduce it to practice is the key language. That's interesting because we're talking about in the patent space. AI being a tool to help enable to help you create and enable your invention. In the copyright space, AI models they're terrible copiers, right? They're never using a one-to-one example. They're
Right.
generating off of tokens, right? Weighted tokens going through a neural network that passes weights to different characters, words, sentences, and generates output. So as far as copying goes, generative AI is a terrible copier. However, it does have access to the material, and that material it does produce starts from somewhere. So, it's a very, very intriguing question. What we're advising clients to do is to be very mindful of what they're using. If they're using a general AI model, such as ChatGPT, Claude, any of the others, that content, you need to be aware of the license that's tied to that content to even use that application. Further, you need to figure out, well, okay, similar to the New York Times case, is there an artist out there that's going to deem this image that I created for my website and I am using for marketing close enough to their image that they could bring a copyright lawsuit? So, there's a lot of perils in there, and it really is tying to how specialized is that corpus of information you're using to generate the content, right? Is it a corpus of open source material that you're freely allowed to use, or are you using proprietary information that's likely under copyright? So very good question. Lot to figure out.
This is another maybe more technical question that I should ask since I'm not an IP lawyer, but is there any problem with using AI in the development of a patent in terms of getting approval from the patent office? Is that something you have to disclose, and does that impact your chances of getting approved?
Yeah, so a lot of perils there. You're not really going to, there's certain AI tools now out there that help you identify issues or spot issues in office actions and things to get you to a patent. Not really on the lawyer side is there much peril. It's on the inventor
Right.
side. So if you're an inventor and you're starting to plug away and you're prompt engineering to try to figure out your solution, that's probably going to fall into the scope of not being patentable. You have
Okay.
to actually conceive of the idea. You have to have it, you know, in hand, pretty well fleshed out. And then you're asking AI to say, test the metrics,
Right.
test the wind speed
That makes
equation on
sense.
this,
Right.
right? Yeah.
Yeah, that makes sense. Another thing that you and your team do in the IP space is dealing with mergers and acquisitions. You're a very valuable part of the M&A team, which we do all over the country, that kind of work. And a lot of the purposes for mergers and acquisitions in some spaces, particularly life sciences, is the IP. That's what someone is interested in acquiring. So what are the methods that life sciences organizations can use to strengthen their IP portfolio and therefore their potential valuation?
That's right. It's a, you know, you, I don't want to oversimplify the venture capital and private equity world, but you really have two buckets. You've got your revenue and you got your IP and your fixed assets, your building and everything else. So, when you're out there fundraising or doing mergers and acquisitions and looking at the value of the company, it really falls into those two buckets. Now, that's a vast simplification. I mean, obviously the business itself is important, where you're at, what you're doing, and the people that are running it. But, one of the things that you can really do to focus on strengthening your portfolio and developing assets that actually matter, or it's more of a harvesting from internal, as well as also looking to the market of what's out there. There's a lot of companies that have a lot of assets that can be purchased. They're in different stages of life. I think of, at IBM, I mean, they sold off some of the concepts to 23andMe, right? Not a good example going through bankruptcy now, but some of these assets are in companies that can be used for other things. And so, I think one of the key ways of strengthening your IP is, first of all, file early and file often. That's always been a mantra of mine. And then second is to look at what assets are out there. Acquiring assets, it can be a really quick way to bolster a portfolio. And oftentimes that's what mergers are for, right? You're acquiring assets. So those are just two of the concepts that we try to talk through with clients.
Another thing that is a factor in life sciences is that everything is smaller now in the world. As we're a digital world, international competition in the life sciences sector is very robust and could get more robust depending on how certain things happen. How do you deal with some of the international intellectual property and trademark protection issues? Because you spend time, energy, and money developing that in the States, and then you're doing business abroad. And how do you have that type of reliable protection when you're expanding into international?
Yeah, that's a great question. The international community for IP is one that's really, really aligned. And, despite what may happen, I think there's a more of a centralization outlook in the world right now where we're looking internally and domesticating things. We're not seeing that in the IP space. I think companies are always projected long term, and they always, their vision's long term. And so we've continued to see increased filings in countries that give really strong reciprocal rights, and that's really your top countries that you file in. It's one of those situations where we see advantageous countries or where you're selling, where you're going to manufacture. It's really tied to the business model and what you're trying to do. But as far as any change, it's remained pretty steady as of late. And anything that we are doing, we're really just communicating with our foreign associates, our colleagues in these other countries. And we get together quite often at conferences and have a really, really close relationship. So
That's good. That's
so
good.
that remains strong.
Final question deals with trade secrets, and we know trade secrets are a critical asset of life sciences companies. It's something that they should strive to protect, and if they do get out, they oftentimes end up in serious litigation to try to reclaim that or deal with the damages. What are some of the ways that companies can be a little bit more aggressive about trade secret protection, and why is that important?
Yeah, so really, I think I've been through quite a few trade secret matters, and I think at the end of the day, one of the hardest things for companies to do is to actually pinpoint and identify what their trade secrets are. Comes up in every single case, right? They say all confidential information is also trade secret information. And I think we have to go back to the definition, and we have to think about what is the definition of a trade secret. And it's something that gains value from not generally being known, right? Not everything in your business is going to be not generally known. Probably 90% of what you do is generally known. You can't throw a trade secret label on that, then march into court and think you're going to win the day, right? And so I like to kind of talk about it as a tiered system. You've got your crown jewels, right? You've got stuff that really, really matters to the business. Product CADs, customer lists, things that are vital to your success in your business. Now, those you want to put a heightened level of security on. You want to have that need to know, certain employees, access control, passwords. We're not talking about building a vault like the recipe for Coca-Cola, but you need to act and protect those to a higher degree than you would, say, secondary tier trade secrets, which may be OEM suppliers or parts lists or specifications, and then third tier. But I always recommend that, despite there's no filing with trade secrets, there's no formalization process, it is because it is, you should always treat it internally as having a tiered system of value for your trade secrets. And I think that is the key, and that's gonna help you and your attorney walk into court and win the day if you can point to and specifically elucidate what trade secrets you have.
Bryan, you have covered a wealth of topics for us today. Thank you so much for that.
Yep.
We wish you the best in your new position as chair of Maynard Nexsen's Intellectual Property Group. And we look forward to continuing the conversation. I'm sure with AI, Matthew, this is going to come up again.
Oh, yes,
so we're going to need to have you come back.
We're just in the beginning of that.
Absolutely. Well, great seeing you, Heather and Matthew. Always a pleasure to talk. We'll talk soon, all right?
Thank you. And for those of you who joined us, we hope you enjoyed today's conversation. Covered a lot of topics, but helpful topics, especially for those of you with startup companies. And on behalf of Matthew and the whole crew here at Taking the Pulse, we look forward to seeing you next time right here on Taking the Pulse, a healthcare and life sciences video podcast.